All right. So, on behalf of Ashwa Legal, from all of us, we wish everyone, all the participants, a very happy Holi. We just had that Holi event yesterday, and today we are here to discuss about jurisdiction issues. So, before that, I'll give a brief introduction of Ashwa Legal Advisors LLP. Uh, Founded in 2017 by founder and partner Advocate CA Dr. Avinash Poddarji and Advocate CA Achal Poddarji, and other partners being Shalin Doshi, Ashu Dalmia, Shefali Girdebal, CA Vishal Poddar, myself, Pramod Dokania, Advocate CA Amish Gandhi, and Advocate CA Avdesh Sharma ji. We are a national level boutique law firm providing legal assistance and litigation support in the areas of taxation, both indirect and direct taxation, PMLA, Benami, all corporate laws, including Companies Act, Insolvency Bankruptcy Code, which is IBC, SURFACI and other statutes, litigation and legal services. Our offices are at Surat being head office, and branch offices are spread across Mumbai, Delhi, Pune, Ahmedabad, Nashik, Vadodara, Faridabad, Gurgaon, Rajkot, and other associate offices spread across India. I think Vishal Bhai is also sharing the slide where we have mentioned our presence. At the same time, I would like to mention that we do have a network associate policy wherein we partner with our associates to give and take both in terms of assignments and knowledge transfer, including handholding. So if any of you are interested in becoming our network associate, you may get in touch with any of our partner offline. With that small brief introduction, I'll hand over the mic to FCA Vishal Poddarji to take the further. Thank you. Vishal.
So, good evening, one and all. I welcome everyone, all the delegates, the learned professionals, tax officials, government officials who are present over here, and many of my industry friends to this very important topic. As you all would have read the flyer, the topic is about issues in jurisdiction. Now, interestingly, whenever we come across any litigation matter, the first thrust as industry, as professional, is looking out for the merit points and the grounds where we can challenge either the merit or we can defend ourselves on the law points. However, many times we miss a very, very important integral aspect of any quasi-judicial and judicial proceedings, that is the presence of appropriate jurisdiction. And time and again, up to the Honorable Apex Court, we all have seen multiple judgments which have come as a savior for the industry in defending themselves some very high stake litigation matters. And many of the referred landmark judgments, including Canon India, have time and again reiterated the fact that jurisdiction is one of the most integral part of any departmental, quasi-judicial, and even judicial actions. So that is why we decided to take up this particular matter for discussion, that is jurisdiction issue. As you can see, our today's deliberation is termed as part 1. Reason being, jurisdiction specifically in GST, that is indirect tax, is very wide. And today will be a starting point, a point where it will be a thought-provoking, thought-invoking session, which may even lead to many of you all delving into these sections, which may normally not be touched upon by many of us in our day-to-day practice, in day-to-day business operations. But this particular first session should serve as a thought-invoking session to give you an outline as to how jurisdiction matters are relevant, specifically in taxation matters, be it income tax, be it GST, customs, and how and where you have to use and invoke this particular point. This is a very small aspect of jurisdiction. Just to start with, to make it easy for everyone, we'll be starting with this small pointer as to what is jurisdiction, what is the impact. And then as we proceed today and in further parts, we will try to delve deeper into each technical aspect of jurisdiction and also how it can be defended in our various litigation cases. I'll request Shefali ji to add her opening remarks before I can start with the PowerPoint presentation.
So, as Vishal has already said, that whenever we are receiving a notice, there is a very important decision making for us. That's whether we should go with the merits of that particular notice, or first of all, we should go to the technical defects it may be having. And jurisdiction may be one of the most, I will say, prominent and repetitive kind of technical defect in the different kind of notices. There are plethora of judgments onto the various aspects of this thing, like when there is an intelligence based proceeding who can send the notices and whatever. So there are multiple judgments, there are multiple aspects, and there are some judgments which are contradictory to each other also. And then it is a long history, like GST Council's recommendation, then notification was issued, not issued, whether it was required to be issued. There is a departmental notice, like circular, sorry, departmental circular, not for the public, wherein they have said that there was not even a requirement to issue any notification, because if there is a restriction, only then we are required to issue a notification. We don't want to put any restriction, so there is no requirement to prescribe any procedure for this particular matter. So I will say this is one of the very prominent issue. And with this, I would like to uh, give it to Vishalji to first of all make us go through the provisions of it first of all.
Fine. Thank you. So let us start with understanding jurisdiction specifically vis-a-vis the taxation matters. So let us understand basically, many times we assume, I'll say, that whatever matters are being initiated against us are having jurisdiction. So we many times go ahead with the matters presuming that there is jurisdiction, and many times either because of our unawareness or either because of too much reliance on the authenticity of the transactions, we miss to check the jurisdiction. Let me just start with a very simple theoretical aspect as to what is jurisdiction. So basically, jurisdiction is the eligibility or the power of a court or of any government agency or department to exercise a particular power. So we all know that under taxation laws, different types of powers are vested with different levels of taxation authorities, starting from the lowest authority to the highest authority. And most important, these powers may be very basic, which may be of simply sending you a notice, sending you an intimation, sending you a summons, or it may be as severe as taking up investigations, taking up searches. Now, for all these different types of actions which are incorporated in the Act, it is very important to understand whether the officer initiating the action is authorized, is competent by the law to take up that action. The officer is an officer, no doubt with that. But whether that designation or whether that officer is empowered, that is what is the meaning of jurisdiction. That is the empowerment, that is the authority, that is the eligibility, if I have to put it very simple, of that particular designated officer to handle that particular matter. Now, to break up jurisdiction, broadly, jurisdiction, according to me, should encompass three different types of aspects. One, as you can see many times in income tax and even in GST cases, you will find that there is personal jurisdiction. Personal jurisdiction means different assessees are under a particular commissionerate, under a particular assessing officer. That is where it becomes a personal jurisdiction. Generally, we find this more in case of income tax cases, where, like in case of individuals, depending upon your surnames, you are assigned to a particular ward or circle where that particular officer is competent to pass an order. Now, this is history because now income tax has moved on towards faceless assessment, but this is the very simple example of personal jurisdiction. This is the most important aspect because this we find, or we will be handling this when we proceed with our deliberation in the other parts of the series, that is the jurisdiction over the subject matter. So when a particular action is initiated by a particular officer, for example, I'll give you a few examples like registration related action, e-waybill related action, search related action. Now, these are all different types of subject matters. Now, the question is whether that particular officer has been empowered by the act or by the relevant notification or circulars to take up that particular action. This is what becomes subject matter jurisdiction. And then comes another very interesting aspect in jurisdiction. Jurisdiction, that is power to render a particular judgment sought. So many times, let us say in case of GST, if I give you a very simple example, DGG Act or any investigation authorities are empowered to issue show cause, but are they empowered to issue the order or pass the judgment on that particular matter? The answer is no. So this is also another jurisdiction where whether that particular authority is empowered to pass a judgment to make adjudication on that particular matter, that is the jurisdiction relating to a particular order or judgment. Now, what are the major grounds where we challenge jurisdiction or we should challenge jurisdiction whenever we are handling any litigation matters? First, lack of jurisdiction. So we should be thorough with the varied circulars, varied notifications which have given the powers to different level or different designated officers to carry out different types of actions. Now, it has been seen in many such cases that the action initiated by a particular officer under a particular section is not at all falling in the jurisdiction of that particular officer. That is, we are challenging that this particular action itself is ultra vires because the officer did not have the particular competency, did not have the authority to initiate that particular matter or take up that particular proceedings. Many times, in case of these cross empowerment cases, as it is famously called as, we find that there is lack of jurisdiction with one of the authorities. So what is lack of jurisdiction? I believe this is the first most crucial aspect which we should definitely take up whenever we are handling any litigation matter, that please check whether the authority taking up that particular matter is empowered to do that, or else you can challenge that there is lack of jurisdiction, the action is ultra vires. Second is, the authority may be empowered to take up that particular matter, let us say whether it be registration, whether it be assessment, whether it be any type of passing of order. But many times there are certain limits that are put, like in case of GST, if I have to give you a practical example, we have monetary limits assigned that up to this particular amount related order, this superintendent can pass the order, then AC, then DC, and so on. Now, many times the officer is having jurisdiction, but there are limits or there are categories. Many times it is seen that the officer surpasses the limits and pass the order beyond the limits which the officer is having. So this is another area where there is no complete lack of jurisdiction, but it is surpassing the limits of jurisdiction. And then comes the third most important point, where first two things are present. That is, there is jurisdiction plus your action is within the limits assigned. But then also there is a very important challenge which we should consider and which we should always take in our grounds, that whether the authority followed the due process provided in the law. So if it is an e-waybill action, there are different forms provided, there are different stages how the entire e-waybill action should be concluded, whether the officer has properly followed, whether he has missed out on some of the actions, whether he has given proper show cause, whether he has given sufficient time to prove your case. Many times we see that there is a breach by the respected authority who is not fitting in the first two grounds of allegation because the person is having jurisdiction and he is working within his limits. However, he may have abused the jurisdiction by not following the defined procedure. So these are the three broad challenges which we normally take up in all the cases, whether it is at the writ level or at the adjudication level, whatever we are handling, including the appeals. Yes, Shefali ji, your insights, please.
So, Vishal ji, first of all, I think the first thing we should be knowing here that from a client's point of view, from a taxpayer's point of view, what kind of relief he can expect from these kind of defects. So in a recent judgment, when there was no DIN, it was not digitally signed. So court said that yes, show cause notice is invalid, but then they, increase the time limit. So they give a time like of 1 week or 2 weeks. So now they said to the authorities that you will be issuing the notice again instead
So
1
sort of
week.
they remanded back, allowing them to
Yes.
rectify the defect.
Although it was already time barred.
Yeah.
So from our SSC's point of view, what kind of relief they can expect? So even in those cases, there can be some relief, like in case
But
of
I think that you're
penalty.
talking about the third aspect where there is only surpassing or breaching of the procedures. Where there is
Yes,
lack of jurisdiction or where there is excessive
it's a
jurisdiction,
different thing.
whatever the past cases we are seeing, it is
Yes,
always that generally the proceedings are quashed or they are nullified. Only I
right.
think where there is breach of the procedure, and that also there is no major breach, it is only a procedural breach. Generally, then they
Mm.
are like how they are giving us the shelter of natural justice. I think it is the shelter of natural justice given to the officers and the department also, that for minor
Yes,
breaches. Yeah.
yes, yes. So if it is completely out of jurisdiction, so again, how we will decide it's out of jurisdiction? First of all, if you are talking about the proceedings, so in some of the judgments, the court has said that proceeding word in itself should be defined. In itself, it should be understood by the taxpayer. So proceeding means some kind of assessment or some kind of adjudication. So if there is only some a kind of summon, if they are just asking some questions, so summon is an inquiry. So if there is a search and the other authority is asking you some questions and they have given you the summon. In one of the judgment, I don't remember the name. I think it was GK Trading. GK Trading was a judgment where the court said that the term proceeding doesn't include the inquiry. When we are issuing a summon to ask some questions, so we have not formed any ground for that purpose. It is just a mere inquiry, right? But the other proceedings will fall under the ambit of proceedings. So we need to understand that what kind of proceeding will actually fall under the ambit of proceeding, and which is just which of them are only a mere inquiry. So that is also important to understand. Although in some other judgments where there were multiple proceedings by the multiple departments, like some from the Ahmedabad DGGI, some from the Gautam Budh Nagar, like from the Noida. There, the court stayed all of the proceeding, and they said that only one authority will be proceeding in that particular matter. So I think there is some lack of clarity from the side of courts also, and not just the technicalities or procedures. They also look into some other matters, like some other, I will say, some other issues in each and every case. So if they find that it's a viable case, they will give the relief. Otherwise, they won't give relief in these kind of judgments, in these kind of cases.
Aptly put, ma'am. Avinash Bhaiya, any inputs from your side?
To be very honest, no. Reason being, we have just started discussing on jurisdiction. And the words which you used was a deep dive into the concept of jurisdiction. So for getting a deep dive, all this what we are discussing is only at the inception level. So I personally believe that let us first proceed and try to delve into section 3, section 5. Thereafter, we'll try to delve upon some of the aspects. But before moving further, one thing I would like to certainly share, that all those challenges of jurisdiction which is there in the writ appeals or the writ forums should be avoided, because that is what is going to happen. As Shefali ma'am said, that the court has remanded it back, extending the time limit for issuance or correction of the error that was made. I would suggest in all these jurisdictional issues wherein we are confident and there is no existence of an unjust, what I can say, unfair hearing. There is hearing was given, we appeared, we challenged the jurisdiction in the hearing, but that was not taken into consideration. Don't go and file a writ. Go and file appeal. I'm very sure at the second level or maybe at the High Court level, when this question of jurisdiction will be raised as a substantial question of law, the order will be quashed and then there will be no remanding back. I hope I'm very clear. When we'll go for a writ petition saying that there is a violation of a fundamental right, and therefore we were not heard and the jurisdiction was not there, it is only a temporary relief that we'll get. If we want to get a final relief or a substantial relief, then in that case, we must challenge the jurisdiction at the level of appellate authority and not at the level of writ authority. But there may arise a situation wherein we are not heard. There is absolutely breach of fundamental rights, or we are expecting that over and above this jurisdiction issue, the amount which is demanded is very substantial, and therefore the pre-deposit is going to cause some prejudice to us. or harassment to us, then in that case, certainly you can go and file a writ petition. But otherwise, challenging a jurisdiction at the writ forum may not be appropriate if the authority has presumed jurisdiction wherein it was within authority of law, but without or maybe out of the territorial limits or maybe out of the monetary limits. So in that case, we can also opt for the other option, which is the appeal, and that is the appropriate forum. I'll stretch upon this when we'll discuss further.
Perfect. So let us now dive deep. So if I have to take you through the provisions first, which is our basic today's agenda, so that we set a tone for our further discussions also. So we start with the first most important concept. See, the entire jurisdiction is enshrined in 3 sections majorly, which is section 3, 4, 5, and then there is one more provision 6. Today we are covering 3, 4, 5, but before that, the entire provision of jurisdiction, I can say, is encompassed or is fitted in one word, that is proper officer. Because everywhere in the law, when you read different provisions, whether it relates to adjudication, whether it relates to inquiry, summons, etc., in many places you will find that the person who is entrusted with that particular section's powers, duties, and responsibilities, it is named as the proper officer. So who is a proper officer? So section 2 clause 91 has defined it, saying that in relation to any function to be performed under the act, means the commissioner or the officer of the central tax who is assigned that function by the commissioner. Now I've underlined 2 important words, and I think this is where the starting of understanding of jurisdiction is. So firstly, the law says it would be the commissioner, and most importantly, it further says it could be any other officer. Now we are reading this from the central tax, so you'll find the word central officer or central tax. It is saying it could be any other officer of the central tax. What is very important is who is assigned that function by the commissioner. Now it is very important that if you want to challenge jurisdiction, you have to first check whether that person is assigned that function, and that you will be checking through the various notifications which are issued assigning these functions to different officers other than the commissioner. Now, starting with the provision, I've just tried to purposely collate the provisions of state acts and the central acts. Purposefully, I've put it in a comparative form because I have found some interesting deviations between the two for obvious reasons. That is what we have to understand and discuss. So firstly, section 3 says it deals with who are the officers. It is a list given in both the sections of central and state acts. But the main crisp part is that the central act says the government shall by notification appoint the following classes of officer to act as the proper officer, and then it says chief commissioner, principal commissioner, commissioner, additional, joint, deputy, etc. Similarly, here also it says it is the government who shall by notification. Now here, why I'm emphasizing on this, it appears to be very plain on the face of it, but you will find that there are even circulars dealing with jurisdictional issues. This is where it becomes important to understand how you will check the jurisdiction eligibility. So wherever it is relating to appointment of the officers, firstly, it has to be done by the government. It cannot be done by the board or any other authority. This is also important. And it has to be done only by way of notification. Here, I would like to mention that if I'm talking about central notification, the mother or the principal notification relating to this is notification number 2/2017 central tax. So whoever wishes to get more details of this, you have to follow central tax notification number 2/2017 and all the related amendments which are happening even till date. So this is the most important point in section 3, which deals with officers. Now we come to appointment of officers. Interestingly, when you read officer, it says the government shall by notification appoint, whereas when you read appointment of officers, here in central law and in the state laws, you will find a slight deviation in the terminology. What does the central law says? The board may, in addition to the officers as may be notified by the government, what we just saw in section 3, appoint such officers as it may think fit to be the officers under this act. So under the central law, besides the government, section 4 has further delegated this particular responsibility role even to the board, which is today the CBIC board, which says that besides these officers, even the board may appoint such persons who can be fit to be the officers under the act. However, when you go to the state acts, section 4 says the government may appoint such persons who can act as officers. Now, interestingly, the difference which I could find out on the face of it, is that Section 4 is empowering or delegating the power to the board. And in case of state acts, it is still with the government to appoint such other officers as it thinks fit. If I go to the parallel section of the IGST Act, which deals with appointment, which is Section 3, it simply says the board may appoint the central tax officers as it thinks fit to exercise the powers of the IGST Act also. So for IGST, the central officers are supposed to be the by default officers even for the IGST Act. Shefali ji. We are yet to go to the next part of Section 4. We are only covering subsection 1. Most important subsection 2 is in the next slide. So if you have any inputs on this, you may just add.
There's no such important input in this. Let's go to the next part.
Perfect. Now here I have one question, that when Section 4 says the board may, in addition to the officers as may be notified by the government, appoint such officers as it thinks fit. Here it is not mentioning how the board will be appointing these officers. So here I believe it should be by way of circulars, because that is only what the power the board has. The board does not have the power to issue notifications. So it would be circulars. And when we go further to Section 5, you'll find that again, there is one part where it says by way of order. Now, this is also very important, that wherever the law specifies the mechanism of doing something, you have to also check whether the same mechanism has been followed. So where it is saying by order, it has to be done only by way of order. Like here, it is not mentioning anything. So I interpret it like this, that here the board shall be appointing the further officers by way of circulars. And we have seen circulars doing the same.
Right.
Should we proceed? Now moving ahead. Now this, according to me, is a very important part in Section 4, which again deals with appointment of officers only. Central Act says, without prejudice to the provisions of subsection on which we just read, the board may by order authorize any officer referred to in clauses A to H. This is the list of officers given, which includes from principal commissioner up to the joint and additional commissioner. What it says, the board may by order authorize any of the officers referred to in this list to appoint officers of central tax below the rank of assistant commissioner for the administration of this act. So here, all the officers initially up to the rank of assistant are notified by the government in notification number 2/2017. But officers below that rank would be, you can say, appointed or authorized by the board. And here it has to be done by the way of orders. And we have 1 or 2 orders relating to this also. But this is again important, that for officers below rank of AC, you have to check for the relevant orders. Now here, State Act is slightly different. The State Act says that the commissioner shall have jurisdiction over the entire state. Fine, because commissioner is the highest authority in state. We have slight difference in the hierarchy. So in state, the commissioner is the highest authority, and generally it is an administrative officer. It is not the adjudicating officer when it comes to state. However, what is very important, which I have found and which I have marked here for your future reference, there is a special commissioner and also there is additional commissioner. And what is very important is this part, which is put in bold. So the special commissioner and an additional commissioner, in respect of all or any of the functions assigned to them, shall have jurisdiction over whole of the states. So now this is very important, that when any action is initiated either by the special commissioner or by the additional commissioner, we are talking about the state, you have to look out for the relevant empowerment of that special commissioner or the additional commissioner, because it is not by default that they are appointed or they have been empowered for doing all the functions. So here it is specifically mentioned, as you can see in the act itself, in respect of all or any of the functions assigned. So whatever functions are specifically assigned. See why I'm emphasizing on this, because when we are testing jurisdiction, many times it may happen that we also, and at the end of department also, jurisdiction is presumed. So action may be taken by such an authority who may otherwise not be having the appropriate power or jurisdiction over the same. So these are the minute points which we are trying to bring across to you through the medium of this particular deliberation today, where you need to focus on whenever you are handling any particular issue or matter. So this was an important point which I felt or I found as an important distinguishing factor when it comes to appointment of the officers and assigning them their respective powers and jurisdiction. Yes, Shefali, any inputs from your side?
I think it's fine. You already explained it.
Okay, perfect. Now coming to the crucial section, according to me, which is now going to take ahead our today's deliberation, that is the powers of all these officers. Because when it comes to jurisdiction, it is basically the powers assigned to them. So section 5 under both state and central law has 4 subsections. I have purposefully minimized subsection 1 and 4 because according to me it is not so important over here for today's discussion. What does subsection 2 says? An officer of central tax may exercise the powers and discharge the duties conferred or imposed under this act on any other officer of the central tax who is subordinate to him. Now this is an implied jurisdiction according to me. So where a and a power or a particular authority is assigned by the board and it is assigned to a lower rank officer, the higher rank officer assumes that authority by default because of section 5.2. That is the basic understanding. So if let us say it is a small function like issuing a summon or taking up a particular small matter in adjudication, that matter may be assigned to a superintendent or let us say an assistant commissioner, but that can very well be handled even by joint commissioner, and that will not require any specific notification or circular issued for that purpose because they are authorized for this particular, I will say, superior jurisdiction by way of 5.2. However, when it comes to 5.3, which according to me has a lot of relevance because we are seeing breach of this in some of the cases, it says that the commissioner may, subject to such conditions and limitations as may be specified in this behalf by him, delegate his powers to any other officer who is subordinate to him. Now here it is the other way around. So a higher authority is delegating the power to the lower authority, which the law says the commissioner may do so. And it is obvious that the commissioner, being the highest authority in a commissionerate, may not run around each and every small matter. So definitely it will be delegating the authority. But the point is how it will be delegating, or if I want to test whether the officer who is taking a particular action is having that authority by proper delegation, what is the document or what is that particular source where I need to check this? This is my moot question over here. So where a power is assigned to commissioner, the commissioner is allowed to delegate it to the lower rank officers. But I think here we need to test that particular document through which this particular delegation is happening. Over to you, Chef Aliji.
So in this particular matter, there are one or two issues I will say. The first thing is that if something is the duty of my subordinate, I can always do it. So assuming that a senior authority will have the knowledge and I will say intelligence to do the duties of his subordinate, so they can do anything. That there is no requirement of any authorization or any empowerment for them. But if my subordinate, who is not or may not be sometimes equipped to do the tasks which I am assigned personally, so in that case, I will be required to delegate them. Now, the second thing is how it will be delegated. So they can delegate it through a proper notification, or they can delegate it through the internal department's authorization. Now, there is one important question: is if something is already issued by the CBIC, like for example, in case the CBIC has already issued a list wherein they have mentioned some monetary limits. Let us say there is a show cause notice, and they have said that for this particular show cause notice, if it is up to say 20 lakh rupees, then only this designation of person can issue it. And if it is like more than 20 lakh and up to 1 crore, then this person of designation can issue it. Now, the important thing is if something is already issued by the CBIC or already declared by the board, then whether they can also, shift those kind of rights to their subordinates. So if say I'm a joint commissioner, I can issue a particular notice, but through my internal, authorization, can I also give that power to a subordinate, to a superintendent or to someone else? So if they will also be able to issue a notice which is higher than that particular amount. So if I will say it should not be like that, because then there will be no benefit and then there will be no sense in issuance of those kind of notifications. But in some cases this may come to the rescue of the department itself. In some cases they may try to do this, because if say due to paucity of time or due to lack of procedure, for any reason, if any of my superintendent has issued a particular notice or passed a particular order, later on we can say that we have some internal authorization and I passed on that particular right of me to him. But practically this should not happen. So this is also important, that what kind of work, what kind of task they can delegate to their subordinates. So it should not be each and everything. It should still be restricted. So if something is already restricted by the board, if something is already assigned to a senior authority, that should not be delegated to their subordinates.
I'll request Avinash ji to come in with his views on the aspects of section 3, 4, and 5, because that will take us more deeper to the various jurisdictional issues and aspects.
No, today our agenda is not to go that deep. See, 5.3 and 5.2. 5.3 specifically, if not implemented with the right spirit, would be a big challenge. And one of the questions which reached up till the apex court, specifically in GST, I'm talking about GST only as of now, was in the case of Radhakrishna Industries. The fight is how the law conceives a particular provision. If we read section 69, if we read section 83, starts with commissioner. There are two kinds of commissioners in the law. One is commissioner in board and the other one is commissioner. When the law says commissioner, it means only commissioner because he is defined in the law. Now it says that when commissioner is of the opinion, or when it says when the commissioner has reasons to believe, the question which arose was, can that reason to believe, or can that aspect of having the reason to believe, or can that aspect of framing an opinion be delegated? Meaning thereby a commissioner has to decide whether in his opinion the provisional attachment is mandatory or not, or necessary or not. For example, commissioner has to have reasons to believe whether the arrest is required in a particular case or not. So the question arises whether can in those cases the power can be delegated as per subsection 3 of section 5, that now commissioner will say, I am appointing an assistant commissioner. He can go and take the opinion, he can frame an opinion, or he can have the reasons to believe that the arrest can be done or the attachment can happen. This has been answered in Radhakrishna Industries, but there will be two different answers, one for central and the other one for state. Because as per me, when it comes to center, it cannot be allocated. It cannot be delegated. It has to be the commissioner himself. He has to pass an order. He has to have the reasons to believe. He has to have the opinion framed by him by own self. He cannot delegate this opinion or this reason to believe power to anyone who is subordinate to him, taking the shelter of subsection 3. But when it comes to state, we have seen that in state, the entire power vests with commissioner. And therefore, in Radhakrishna Industries, there was a concept of joint commissioner has taken that call. Honorable Apex Court said that joint commissioner can take this call. He can frame his opinion for the purpose of attachment. This question has been dealt with by the Gujarat High Court also in multiple judgments, more specifically Velarius. It has been discussed, but it has not been decided because that was not the mute question. So what I want to say is, when it comes to section 5.3, it is certainly going to be looked into whether the delegation is within the authority of delegating or not. As rightly mentioned by Shefali ma'am, that if I have a power to adjudicate to a particular level, then upper is okay. It's let's say it's a show cause notice of 2 crore rupees or 1 crore 90 lakh rupees. The assistant commissioner or deputy commissioner is empowered or having the jurisdiction to decide that particular show cause notice. Can that officer delegate this to a superintendent under section 5 subsection 3? That is what is being raised by Shivali ma'am. The answer is absolutely no. It cannot be done as per my limited understanding. So let the discussion proceed. I am very sure that this is going to take a lot of time because this is not going to complete in a day or two, because we have to deal with notification of 2 of 2022 also, and thereafter the circular of 169 also. So we'll be dealing when we'll deal with that. I'll look into all these aspects in a deeper way, because there are a lot of like the questions which can arise or which has to be dealt with would be, can multiple notices be there in the same show cause notice? Can a person not having jurisdiction on the multiple notices pass an order? All those things we'll discuss in the times to come. So for today, I can say 5.3 is certainly risky, and therefore we have to cross check whether the person who is delegating has the power to delegate or not. Merely because the law says, I don't think that he will get or he can have the power automatically to delegate the functions. He has to have uh, the the jurisdiction to delegate such powers. That is what I can say. Because it is commissioner, the order has to be passed by commissioner, and generally it can be observed that no executive commissioner delegates that power. It is commissioner in board only. We can see multiple circulars, we can see multiple instructions which says that this power assigned to this section adjudication assigned to this, whether he is the proper commissioner or it talks about the commissioner in executive. This also needs to be evaluated in future. So we can take up all these issues we'll take up in the next part.
Yes. So this is all about the major sections that are covering jurisdiction. Shefali, if you want to take up any particular point, we can take that deliberation before we can go to the question answers from the participants. But I think today's question should be very limited only to the pointers that we are discussing. Yes.
Yes, we are not diving very deep into the issues, otherwise, this will be having a lot of issues. But I would like to, I will say, I will mention it again. The two very important things which Avinashji have pointed out for all of the listeners. This is something you should note down. I mean, when you were saying maybe you haven't thought it into that much of depth. As Avinashji said, that when there is some kind of technical issue, it's better to go for appeal. And that is very intelligent advice he has given. The reason being that when we are going to appeal, that is the statutory code, they will not go anywhere beyond what is written in law itself. So they will not increase the time limit for show cause notice, or they will not give you any relief in terms of time. But when you go to the writ is a constitutional code, they can give you some kind of relief, which is not even given in the law, but they can go beyond the, what is written in law, beyond the limitations of law. So in that particular case, generally we say that we should go to the writ. That is more beneficial because we have more leverage, we have more powers there. But in this particular case, we should approach through the appeal, because going to a writ will give more flexibility to the court, and that will result in a negativity, or I will say a loss to the taxpayer. So I think this is very, very, very important advice he has given. First thing, and second thing is about the jurisdiction, the shifting your role to your subordinates. That is also very important thing he has said, that you cannot, just because the right is given in 5.3, it doesn't mean that you will be able to shift each and everything. There should definitely be a limit on it, right? So I think these are two very, very important things, very important, and the writ thing was very, very important.
Yes.
Vishal, just one thing.
Yeah.
You mentioned when there was a slide, there was something like types of jurisdiction or something was there.
First slide. Yeah. Okay.
Right. What was those three things?
I'll just share it again on the screen, and maybe we can. Yeah.
Okay. Lack of jurisdiction, then it was excessive jurisdiction.
Yeah, and abuse of jurisdiction.
Acha. Okay. Fine. So I think
Yes.
as
Somebody has asked, what is the difference between commissioner and commissioner in executive, or I think the one which you are mentioning, commissioner in board.
commissioner and commissioner in board are already defined in the law.
Hmm.
Wherein commissioner is board is the person who is sitting as a commissioner or posted as a commissioner, who is sitting there in the north block with the finance secretary. He takes call, he issues the circulars and everything. So therefore he is the circular in the person who is he is the person who is the authority sitting in board, and therefore whatever circulars or instructions are being issued, it is being issued by that person said to be a commissioner in board. And commissioner executive means a regular person who has been allowed or allotted the commissionerate, who is heading that commissionerate and acting as an executive or administrator for that particular commissionerate.
Perfect.
So I was
So
just talking about this
yeah.
lack of jurisdiction and all. See, there are a number of examples, there are a number of things which we can discuss, and certainly in the next forum, during the next occasion, maybe next week or maybe fortnightly, we'll frame certain questions on various jurisdictional aspects which are there, and we'll also try to dwell upon when a writ is maintainable, writ we should go for a writ, or when we should go for an appeal, or when we should challenge the law, because that is also something which is very important, that at times it's not a case that we are supposed to follow a particular law. We can also challenge a law if it is not correct. If we find that it is not correct, if the circular is not appropriate, then it may not be appropriate to follow that circular. I'll just give one example. A person, let's say he is in Maharashtra, he is registered in Maharashtra, and his administrative jurisdiction is with the state authorities. Now, please try to understand, he has supplied certain goods to Mr. X, or maybe he has procured certain goods from Mr. X. There are certain DGGI or maybe search actions initiated by the DGGI against X or any person who is there in the chain. The show cause notice is issued, let's say, by DGGI Delhi. One of the circulars says that if there are multiple notices in one show cause notice, then whosoever will have the jurisdiction of the place wherein the principal place of business of one of the notices are located, which has the maximum tax liability, that would adjudicate the entire show cause notice. Fair enough. Let us believe that that circular is right. Let us believe that notification is correct. But can a central notification or a central circular be binding on a person who has the jurisdiction of state authorities in Maharashtra? I would have taken this as a correct circular. So therefore, he can assume jurisdiction on a person or on a taxpayer who has the jurisdiction within central limits or central state, central. But a person who is there in the state jurisdiction, can he go for the adjudication, a person of the central GST sitting in Delhi or sitting at the principal place of business where the maximum tax liability is there? So this is just one example. Another example, when it comes to, so that is an example of excessive jurisdiction, which is not there in the law. You have no limit, you have no territorial boundaries. So that is excessive jurisdiction, which travels much beyond the boundary, and you adjudicate those matters. So therefore, that has the lacuna of excessive jurisdiction. Now, when it comes to lack of jurisdiction, it is very important, because nowadays, even in Gujarat High Court, we have challenged, we got an interim relief also in couple of matters, wherein what is happening, most of the central authorities are doing this, specifically those cases which are either audited by the commissioner of audit commissionerate, or those matters which are investigated by the DGGI. So what is happening is, let's say DGGI additional director or joint director is issuing a show cause notice to Mr. X. The procedure says that this DGGI officer can only issue a show cause notice, but it has to be adjudicated by the executive commissionerate, by the additional commissioner, joint commissioner, depending on the monetary limits. Meaning thereby, after issuance of a show cause notice, it will be sent to the jurisdictional commissionerate, and then jurisdictional commissionerate had to adjudicate it. So therefore, if we read section 74 or section 73, subsection 2, it says a show cause notice shall be issued at least 3 months prior. In case of 74, at least 6 months prior. It says it shall be issued. It never says served. So DGGI can issue a show cause notice, let's say on 1st of July, and then it can send it to the executive commissionerate. And thereafter, the executive commissionerate, who has the jurisdiction to adjudicate that particular show cause notice. Because whenever you will see that DGGI show cause notice, it will also say you have to show cause to additional commissioners, central and so GST, falana commissionerate. Meaning thereby he is your adjudicating authority, additional commissioner or joint commissioner or whosoever. So requirement is, as per rule 142, now that additional commissioner or joint commissioner who has to adjudicate this case will serve the show cause notice to me along with the DRC 01. Here comes the catch. बहुत सारे लोग उस पर दिमाग नहीं लगाते, but here comes the catch. Now this DGGI officer has issued the show cause notice, let's say on 1st July. He has sent it on 7th July to additional commissioner's office. Additional commissioner has uploaded this DRC 01 on 15th of July. But DRC 01 is uploaded from the login of assistant commissioner or superintendent. Mostly you will find it is uploaded from the portal or from the login of superintendent. That is something which is beyond jurisdiction. It is not permissible because the proper officer to issue a show cause notice and the proper officer to upload DRC 01 cannot be two officers. Gujarat High Court has already taken this into cognizance and issued notice also to the other side. Even interim relief has been given. So the point which I am trying to raise is, law has given one concept of issuance of show cause notice. So DGGI audit, they can issue show cause notice. But then it has to be served. And that service of that show cause notice is dealt with in Rule 142, which says the proper officer shall serve along with the notice a summary thereof in DRC 01. So it has to be served within that time limit which is prescribed in the law. At the same time, it has to be served by the proper officer. So when it comes to lack of jurisdiction, show cause notice was issued by the correct person, joint director or additional director. But when it comes to DRC 01, it is uploaded by superintendent, and therefore that superintendent lacks that jurisdiction. He do not have that jurisdiction to upload DRC 01, which is to be adjudicated by the joint commissioner or additional commissioner. I hope I am clear. So that can be an example of lack of jurisdiction. And when it comes to abuse of jurisdiction, so here we have to understand the difference between jurisdiction and power. We have to understand the difference between the jurisdiction and power, and the jurisdiction and power has to be referred that a jurisdiction has reference to the power. See, jurisdiction means what? Power to adjudicate. That is jurisdiction. Power to administer a particular person. So therefore, the exercise of the power and the extent to which the powers can be used will define the jurisdiction. And therefore, abuse of jurisdiction can be where you have no power and you have exercised that power. The example again can be 5 subsection 3, wherein a commissioner was supposed to decide whether the provisional attachment is necessary to be done or not. Whereas now he has assigned that power using section 5.3 to a to a superintendent or maybe to an assistant commissioner. That is abuse of power, abuse of jurisdiction, because he was having jurisdiction. He has abused that jurisdiction to an extent that he has given that jurisdiction to someone else. So this can be one of the examples. This is just, I wanted to touch upon, rather Vishal Bhai has told me to touch upon all these aspects. I said that I'll certainly touch upon, but when the time will come after the discussion, if it is required, I'll touch upon.
Excellent. So participants, as you saw, today we kick-started the discussion on jurisdiction. Now our further series on this, further parts of this particular aspect of jurisdiction would be covering, taking up the varied issues, like few of them are just started by Avinash. Now we'll be taking up varied cases and we'll be deliberating on how these cases fit into the jurisdictional aspect. And as importantly highlighted by Avinash, we'll also try to find out a sort of solution for our clients that when we should prefer a writ and it would be more suitable, as was also discussed by Shefali ji, and where it is more appropriate for us to suggest our clients that instead of challenging the jurisdiction in writ, you should take up the matter in appeal. And since in appeal, the appellate authorities have to follow strictly the law, they do not have that special leverage what the courts have. There, it may be more beneficial from the client's perspective to get a better result, I would say. So this is what we will be now taking up
One
from
more
the
thing.
next part, the various issues one by one.
Well,
Yes,
if I may be permitted, just one more aspect.
please, sir.
See, please don't misunderstand the power of the court to rewrite the law. No, that is not within the power of court. Court can at the most remove the defects in the jurisdiction. Or rather, let me put it in this way, court cannot remove the defect. Court can use the or exercise the extraordinary jurisdiction under Article 226 and pass an order to create an equitable balance between the wrong procedure or between the lack of jurisdiction and at the same time the interest of the taxpayer. Meaning thereby, it is not always right to say that writ is not the right forum. Writ is the right forum because it saves a lot of energy, it saves lots of time, it saves a lot of money. But at the same time, when it comes to challenge of jurisdiction or when it comes to only a technical challenge, the end result is going to be remanding it back. Then we have to analyze, then we have to think upon whether it is to be sought for or whether we should go for appeal. But one thing is very clear and very sure about it that a court can never add even a single word to whatever is written in the law. So therefore, if law says 30 days condonable, then court cannot make it 31st day. That is the only point which I am trying to raise, even the appellate authority. So if something is not doable in Article 226, it can never be done in writ. In appellate forum. Please appreciate that.
Great. So I think with these pinpointed inputs, we will now close our today's deliberation. All the participants present here, whoever you are connected with from one of us, please post your specific questions, because now the next part of this particular series will be pinpointed only on the specific queries, issues, maybe designed in FAQ format, taking up different cases for discussion, so that after this basic introduction to the jurisdiction aspect, now we can understand how to use this jurisdiction while challenging or while handling various cases. So with this, I think we conclude our today's deliberation. If anybody wants to add any closing remarks, kindly do that, or else we can close our today's deliberation.
The questions are there or not? There are no questions.
I'll just add up, I'll read out one I already took off Naveen ji. Next is of Pradeep ji. I think you answered that. That is why I did not take up that question. Pradeep ji is saying, in the case of DGGI show cause spreading to number of jurisdiction, can one jurisdiction where DGGI is located, can it adjudicate the matter? So I think you have already said that it is a point which is challengeable, and you also explain on what grounds we can challenge it. But Pradeep ji, I think this would be discussed even more in detail when we are taking up that particular point as a specific case study. But I think this is already answered by Avinash ji partially. Punuji is saying, if you allow, I want to add some inputs. Sir, you can please do that. But I think now since we are closing, you can do it personally to one of us. We'll definitely include this in our next deliberation. So there are no specific questions on the forum. And I think we could add a good insight on the subject and to trigger your thought process and your excitement, I'll say, on the subject matter. And now looking forward to inputs and cases from your side where you want us to deliberate. We already have our set of pointers ready for the next part. If anybody wants to contribute to that, you may please feel free to connect to any one of us, so that from the next part of the series, we will take up the issue-based discussion. So that's it all from my side. Pramod ji, if you want to give some closing remarks.
Yeah, I think it was very informative session, and I think we are prepared to have more enlightening session on this topic in the next person. So on behalf of Ashwa Legal Advisors LLP, I thank you all the participants once again to join this session, and also thank you Vishalji and Shefaliji to deliberate on this important topic, and a special thank to Avinash Bhai also to enlighten his knowledge on this and sharing it with all of us. Thank you once again and good night.
Thank you all. Thank you very much for joining. Thank you.
Thank you.